Hey, everybody. It's Mark Schipper from Fifth Down College Football, 5D CFB on X, Instagram, TikTok, YouTube. Please subscribe, like, share, tell your friends. Every little bit helps. Appreciating you guys there. Today, I have a top shelf guest. He's an attorney, podcaster, professor. He's a man about town, arguably the best hair in the game. It's Dan Lust at Sports Law Lust on X. Dan, thanks for coming in. How you doing today? And how would you describe yourself to the people?
I like the intro. I like the hair compliment. And so we're starting off on a really good foot.
Yes, sir.
I would describe myself, it's a good question. I don't know if I've ever been asked this. I would describe myself as a diehard sports fan who happened to pick a profession, law, and studying the law as a professor and a lawyer that, like to dabble in the arts here. So, but I do approach these topics as a sports fan first. And then, I certainly represent agents, coaches, schools, collectives, so very involved in this space. So, yeah, we could have a fun time breaking down a number of topics today.
Yeah, you're all over the place. Your stuff is almost uniformly great, or it is uniformly great. What is the name of the book you just released, sort of going over the series of legal events in college athletics?
Sure. So I just released a book called College Sports Law in a Nutshell. If you're wondering if that name sounds familiar, there's a series of books in law school called like Criminal Law in a Nutshell, Property Law in a Nutshell. And it's, I want to say a condensed version of the last 100 years of college sports, the biggest stories in college football, all the way through the present. So a blending of the old school, new school. You can just Google that College Sports Law in a Nutshell. I wrote that alongside a co-author from Ole Miss. So we got the Northeast. I'm from New York, and we got Professor Will Berry over in football country in the Southeast. So we got all corners hit.
You got it absolutely covered. You got the beginning of the sport in the Northeast, and you got the sort of current hearth of the sport in the Southeast. And that's a fascinating way to look at college athletics. I do a lot of that as well from a historical perspective. It really is. There's the game itself on the field. There's everything we associate with college football, the fandom, and all of that. But the sort of philosophical framework, legal framework, and the way college athletics has worked through the centuries now and the decades is actually really the heart of the story. Not a lot of people going to look at that, but when you do, the sport itself and the situations we find ourselves in make a lot more sense, I think.
Yeah. I'm a historian. I'm a academic. But yeah, it's a very fun time for college sports. Just where we were, and then these last 3 years, we've had a whole new era of college sports, and then the next 3 years will be even different beyond that.
Yeah, absolutely. It's I've called it a revolution. This whole thing, this whole Fifth Down College Football is a book project, as people who follow me know, started in 2021, really odyssey across the country. But the two essentially theses that I had at the outset were that college football is inseparable from American history and culture in a unique way, and the sport's on the verge of a revolutionary change. And really just, I mean, less than a year after I started saying that, the earthquake started to rock the sport. That's how I came across your account and your input and output on the game. And that's sort of what leads us here today. So I asked you on to talk about the epochal house settlement, which is, it's kind of part of a series of actions in the courts that have happened in college football. They're not necessarily tethered together, but they're at minimum tangentially related. So we have like the Ed O'Bannon case, the Elston case, and now the house settlement. This house settlement has set aside $2.75 billion to recompense college athletes who may have missed out on earnings in an earlier period. And it sets up a structural framework going forward, they hope, for athletes to be paid directly by their universities and to be able to participate in the private marketplace. So, Dan, when you look at the house settlement, what do you see from your perspective, and what are they trying to do with this settlement?
Well, I guess people are calling it settlement. I want to make clear that it's not like officially settled yet. I mean, so Mark, when are people going to be listening to this episode? Like in the very near future?
Yeah, very near future.
So at least as of time that we're recording this, it's somewhat up in the air whether the judge is going to approve this settlement or not. So we can certainly unpack it. But I guess there's a couple moving parts here, right? There's the conversation of whether athletes and schools are going to fight this unionization issue, whether they're going to revenue share. There's a lot of different cases here, but at least for the House case, and want to make sure we hit that. That's the biggest one. We have a proposed settlement. It's not an approved settlement. That was the hearing last week, was whether or not the judge was going to approve this settlement. And as part of that process, the judge had to answer and listen to a lot of people that wanted the settlement to fail. So that could be the collectives, right? That could be other plaintiffs in other states that are not going to necessarily collect if this case is settled. The attorney general from South Dakota. There's a lot of people that don't necessarily like the settlement. And although the settlement is very big in terms of college athlete rights, like, for example, schools can spend up to $20 million of their revenue on athletes. There are people, and I don't try not to pick sides in this because I represent some athletes, I represent schools, so I just tell you like it is. There is, I think, a fair argument that if we are this case itself, House versus NCAA, is a case that's built on the definition of NIL. Okay, so athletes can make money off of third-party marketing deals. So if they do a used car commercial or a whatever type of third party, that's fine. But the way that NIL was drafted and kind of codified around the country was that school revenue sharing would not be included. So that's why the schools are offering up in the settlement, okay, we'll give you guys $20 million, up to $20 million. The problem with that cap of 20 million is that it can be viewed by some as being anti-competitive. Why can't a school spend 21 million? What about 25? What about 31? If college athletes make, let's say, like conservatively, $100 million for their university, why are we capping that at $20 million? So those that are coming here and saying all of the caps on college sports, this definition that schools can't revenue, so that's all anti-competitive. So yes, it's great that you're giving us a cap of $20 million, but why is that cap 20 million? Why is there any cap at all? So that's why it's not, a lot of people, since day one of saying this is a done deal and this is over. And it's also important to point out, Mark, that this settlement is not derived by collective bargaining. So it's the plaintiffs, the class action plaintiffs' lawyers, and the NCAA. It has not been approved yet by all players. So it's not by no means a given that this will get done.
Right. I actually have a question about that. It's something I wanted to ask you about is this revenue cap and this sort of negotiation without an actual negotiation. And let me rewind just a second here. I should have been clear about that. I'm calling it the House settlement because that's how it's being laid out in the media. But last week, Judge Claudine Wilkins, I believe her name is, told the two sides to get back together and continue discussing it. And there could potentially be some serious issues with this. But my question on the revenue cap basically is, it appears to be a labor agreement, except without labor on the other side negotiating. It's sort of made on their behalf. To me, that looks like you're getting into a very dicey legal area. So when you look at that, is that likely to go through? Is there a hybrid arrangement available? Or when you look at that situation, what do you see there?
It's a great question. And that's what I was kind of alluding to. Yeah. Just as a brief kind of trip down the law for a second, people can look at the concept of a salary cap. And while that might not be objectionable to sports fans, okay, 20 million, and that's the budget. That makes sense. We're allowed to do that at the professional level because that's something that's collectively bargained for. So the NFL's hard cap, Major League Baseball is the luxury tax issue. You name it. You kind of figured out these max contracts in the NBA. Those are all forms and dynamics that are collectively bargained for, whereas the NFL Players Association will get together with their employer, i.e. the owners, and they'll hammer out this deal. So while that might be viewed as being anti-competitive, right? Like, why is there a salary cap? Why is there a max salary? Why is there a draft where the worst guys have to go to the best team? Those are all anti-competitive. And they'd all, if you went to a courtroom, be viewed as an antitrust violation. But there's an exception. If a union and the employer and the employee formally agree to it, you can get around an antitrust violation. That's why you raise a really interesting point. We're trying to settle the House case. We're trying to come up with something that resembles a collective bargaining agreement. But legally, it's not a collective bargaining agreement, and it's not collectively bargained for from a meeting of minds between an employer rep and an employee rep, because student athletes are not employees yet. So yeah, it's a lot of people are have a lot of poke holes in this, but for the plaintiffs' lawyers here, I think they're doing doing an admirable job trying to find a middle ground here. I'm not one that's going to give the NCAA many compliments. It's just it's just the hill I'm ready to die on. But yeah, this is an agreement that's a valiant effort, but just legally, it's very hard for them to get around antitrust violations, even with this particular settlement. That's why so many people are so unhappy with the terms of this.
Yeah, and you use some interesting terms in like valiant effort, and that's what it is. And it's kind of, we'll circle back to this later, but it's in some ways a really desperate effort, and in some ways maybe a last ditch effort for a certain arrangement in college athletics. So the question has to be asked, why are they doing this? And it's because of the messiness of employment and what employment would mean for these schools to employ athletes. Now, everyone thinks employment would necessarily mean direct employment. The athletes are employees of the school in the way you might be an employee of a school as a professor. When you look at that, do you think that's the only option, direct employment with a state school, and then private schools would have different arrangements? Or is there potentially a way to employ these athletes in a third-party entity like a conference where you could get around some of these state labor laws, some of these university requirements, laws, et cetera, and go through the process that way? And sort of, so the back question to that is, why are the universities and the NCAA so adamant that they do not want to employ athletes directly?
I think it goes both ways, right? If you can cut a player from a team, okay, they might still have, they have certain rights, right? But the problem is, from a scholarship standpoint, right, we understand what that looks like. But let's say if players not performing, you can release them from the school. It's an odd concept. I think schools are going to fight that as long as they can. I think that's why you're having this olive branch, this $20 million cap, because at least they have some control over what it is. If you have true revenue sharing, like you are in the pros, you could have close to a 50-50 revenue share model, which I'm not sure schools are financially equipped to handle, for better or for worse. And I want to make clear, I'm not really, I mean, listen, there are other people whose job it is to find this particular solution. All we can do as lawyers is tell you when there's holes in a particular solution. If somebody wants to retain me to come up with a particular solution, it's fine. The problem is, Mark, there's this weird dynamic right now in the States where there's like no uniform NIL law. So you can find a solution in New York, right, in theory, but that New York solution has to jive with like the schools in the particular conference. It has to jive with what the NCAA is doing. So right now there are certain things that schools are allowed to do in New York, where I'm from, and the law I'm most familiar with, that they don't do. They don't act to the fullest extent permissible by law because they're worried that they're going to face punishment by the NCAA or their particular conference. And I guess within that, to answer this kind of weird quirk with your question, which I've received a couple times, when I'm talking about collectively bargaining in the NFL, that means like all players on all 32 teams have one union. They have the NFLPA. And all the owners, there's 32 of them, they're all represented by one side. So really, as much as there's a lot of thousands of players, and there's owners, and there's different executives, there's really only two people at the table. It's the employers and the employees.
Right.
When you get to the collegiate ranks, it's not that simple, right? You could have a Penn State football union, and then Penn State on the other side. And then separately, you could have a union for Ohio State and Michigan. You could have a union down in Miami, and you might have a lockout or a strike. Some concepts that are more familiar in the labor law setting. But that normally when you have a lockout or a strike at the NFL level or the NHL level or the NBA level, the whole league shuts down. So in this weird model of labor that's fragmented across every state, you might have certain teams that are shut down. So short of a federal bill and short of some real collective bargaining across the NCAA, it's a very fragmented landscape, one that we're just not used to seeing. It's like, Mark, if the Yankees by themselves decided to go on strike and the other 29 teams in Major League Baseball just kept playing, that would be very odd. That's the system that might be in place the next 4 or 5 years in college sports. So, I tell people we're just at the very tip of the iceberg of change here.
Yeah, it's going to be an interesting coming decade for certain. This always reminds me of a quote to give people an idea how long this type of issue has been going on in the NCAA. When the NCAA was formed in 1905, 1906, they had a hard time bringing everybody under a singular umbrella because home rule had been the standard in college athletics, meaning each individual university ruled itself.
Right.
Some joined a conference, and the conference got some level of autonomy over schools or sovereignty over schools, but essentially home rule reigned. And so when they got done creating the NCAA, some wise guy said the colleges agreed collectively to act individually. And we're still sort of living, we're not sort of, we're living in that atmosphere. So you brought up something, we've been talking about NIL, and this was something that Judge Wilkins sort of zeroed in on a couple times last week when she told the sides to get back to bargaining. And there are questions I have for you and wonder if you can shed some light on. The schools and the plaintiffs are trying to decide between two different types of NIL, or distinguish between two types of NIL. Commercial NIL, which they say is legitimate, which reflects market value, and then inducement NIL, which is essentially a collective or some entity paying an athlete to come to school. And they want to try to distinguish between those two. That's a hang up on this agreement. When I look at those two things, I think it's going to be very difficult to do that. And B, I just look back at the history of the NCAA, and it seems to me they're up to their old business again, which is trying to regulate minutia and creating a regulatory situation that might be almost impossible to fairly enforce. So when you look at those two different versions of NIL and what Judge Wilkins said, what do you see there?
I think it's a construct made up by the NCAA. I think, we all have to go back, and it's not really what we think is fair and what's good for college sports. If we're really in court and the toothpaste is out of the tube, so we can't go back. Like the lawyers are involved, like the politicians are involved. It's kind of gone off the rails. So we're here. We just have to make the best of the scenario. And I've always had a problem with the NCAA saying that inducements should not be allowed. Like that's the fabric of a competitive market. That's the fabric of someone being able to switch schools, right? Like the inducement to change, right? That's the era we're in. It's the player empowerment era. And if you don't like your current situation and you tell your current coach, your current OC or DC, hey, I want more playing time, or else I'm going to go in the portal because I'm going to be offered a lot of money. That's the inducement for change. So that's the part that's pro competition. The fact that you can commercialize your NIL when you're already at a school from some entity that's not inducing you to switch your commitment, I think that's very different. Whereas commercial NIL is just you being at your school and being able to make money off your name, image, and likeness. I think you should be able to make money on both, but I think the inducement is one that we can't be without. I think that's probably more important of the two.
When you look at that from a legal framework, and even not looking at this through your attorney glasses, how is the NCAA really going to have an objective process for distinguishing inducement versus commercial marketplace? How is the NCAA going to decide how much an individual is worth to the commercial market? And where are they going to draw the line and say that's where his commercial value ends? The rest of this is inducement. They've proposed this third party entity where players will report their NIL deals and the NCAA will look them over and certify them or not. I don't know how that would work. Do you have any idea how this would work at the NCAA level?
So the first question you ask is, how do you differentiate between the two? How do you figure out what fair market NIL is? And how does this third party entity police this? Like, I'm not really sure how one would do that. I always, I always come kind of looking at this with like a little tinfoil hat situation. Like part of this proposed settlement is like, you have to report every deal over $600. They want to report it to some entity. And I think what they're doing is trying to get enough comparable data to try to figure out what fair market value is.
Sure.
I'm not so sure we need these constraints to have some sense of fair market value. Someone's market is whatever they can get paid for. Like, we'll take it out of this context for a minute. I was just talking to a client about Steve Ballmer's $2 billion purchase of the Los Angeles Clippers. And at the time, it was a blind bidding process, and I think he overbid by $1 billion, something like that, right? And everyone was like, Steve, you won, but like it kind of overbid. It was like, overbidding on your free agent auction in your fantasy football league. But
Right.
like, Steve, why'd you do that? And he's like, well, paraphrasing, but like the market is whatever I want to pay for it. And I've now reset the market. So fair market value is whatever anybody wants to pay, unless I can't really think of a scenario where someone's payment of funds to a top flight blue chip quarterback shouldn't be viewed as fair market value.
Yeah, exactly. That's my issue with it. And it triggers in me a lot of memories and thoughts about what the NCAA has always tried to do in setting caps on things, scholarships that got blown up with the Alston case, levels of payment to player laundry money over the years. And they've always sort of set these artificial caps, and they've really had no way to justify them other than we're trying to make it affordable for everybody and we're trying to keep everybody involved, which is a noble enough view. But the problem is we're in such a naturally uneven marketplace with such different power levels between these universities that it's always just led to disaster, and really it's built dishonesty into the system, whereas people would likely have been honest about things like inducing players to go to school long ago. But the NCAA decided, the schools decided it was illegal, and you've essentially turned people into liars trying to compete in an underground marketplace.
Yeah, I think that's fair. I mean, we've kind of brought this to light in 2024. We're trying to bring it above board, but I guess the other part I'll say is this reporting requirement and bringing everything up for everyone to see. Like in the professional landscape, we don't know the value of anyone's marketing deals. Like we just don't know it. We know their, contracts. Like, we're deep in the weeds in Deshaun Watson stuff. Like we all know he received $230 million guaranteed. We know that. We don't know
Right.
what his endorsement money is. We rarely know what players' endorsement dollars are. Why would college athletes now need to report that? Because we need to protect them in some way, shape, or form. If they have lawyers, agents, financial advisors, I'm not sure, why we can't trust our college athletes with their own funds. I don't know why that needs to be reported. And I just don't know what benefit that serves. I don't know who we're protecting in that model.
Right, exactly. So all this stuff is we're in it, we're around the edges, we're talking about all these things. So this question, maybe seems a little tangential, but it's not. Um, Charlie Baker, president of the NCAA, Greg Sankey, probably the most powerful conference commissioner in college athletics, commissioner of the SEC. They both, after the initial House settlement was announced, nothing official, but when it was announced, they both basically made the point that we're establishing a foundation, a baseline for where we want to be. And now, because we think we have the courts on the side of this deal, we would like for Congress to step in and offer some type of antitrust exemption. This has been the dream of the NCAA for a long time. Congress has done this in the past on several occasions, the NFL TV deal probably being the most famous of all. But when you see Greg Sankey asking for these things, and Charlie Baker, what would it look like if Congress stepped in? And, I don't need you to forecast or anything, but do you think it's likely? Does that sound like a plausible scenario for the NCAA and the conferences?
Two different questions. I mean, do I know why they're doing it? Sure. I think which I can answer in a minute, but the answer of whether it's likely, there've been hearings and congressional hearings on NIL and the need or inquisitions into whether there should be a federal NIL bill since, I don't know, June, April 2021. So for 3.5 years, the top brass in college sports have asked for it, and they haven't got it. So whether I think it's likely, I think it's anyone's bet, but I would think if it was a top priority of Congress, it would have been done already. It doesn't take 3.5 years to pass something like this. So there's some other forces at play. Why it's needed is part of the, what we were talking about earlier. Like, and this is what I tell the students in my law school class. Like, Mark, wherever state you are in the United States of America, you could pop into a bar in Hawaii and the drinking age is 21. You pop into a bar in Florida, drinking age is 21. Anywhere you want. It doesn't mean it's the right rule. It means that we know what the rule is. It's a clean rule. Like I could tell you that 18 is a better age for the drinking age. You could drive a car, you can go to war. Like you probably should be able to have a beer on American soil. Opposite, right? For what we're dealing with here, there is a fragmented state by state approach across the country. So there are different NIL rules depending on which state you go to. And in a conference like the SEC or the Big Ten, there are different states operating within the same conference. So I understand why a federal bill would be helpful. Because imagine if your drinking age, right, 21, use the same concept. We can come up with an NIL rule that might not be the best rule, that might not be the best system, but it's a clean rule. So I understand why they keep going to Congress. I can't tell you the reason why the bill is not getting passed, but I do understand it. And then there's also other factors, right? Right now, players that are here on student visas are not able to as easily make money off their name, image, and likeness, and that can really only be done through the federal level that can change a visa status. So there's other reasons for doing it, but important.
Hey, is there any scuttlebutt? Have you heard anything about the employment model should it come to fruition? Will there be, or are people hoping for an opportunity to potentially not employ athletes through the school, but employ them through the conference, which may give them a different legal standing? Have you heard anything along these lines, or are we not there yet?
I haven't heard it, but I think that would be easier for the same reason I explained. Like if you're unionizing across each team level, I think that's much harder. If you can get it to the NCAA level, great. If you can get to a conference level, fantastic. I think that would be ideal. The only thing I think there's an effort in the Ivy Leagues to try to unionize across like the Ivy League basketball teams. That's what's going on with Dartmouth right now. But I'm not sure of the progress on that front, if any, but I think that would certainly be preferred.
So when Judge Wilkin last week told the two sides to get back together and continue working on this, there was some expression from at least the NCAA side, and I think maybe the plaintiff side too, that they might not be able to get together any closer than they already have. And this may have just been a bluff and may have just been anger coming out on the NCAA side, but there was some suggestion that the NCAA might at this point just allow these cases to go to trial, these suits to go to trial, and to live with the outcome. Now, the NCAA has taken some robust ass kickings over the last 3 decades or so, 4 decades now. And these suits to me look like if the NCAA takes this all just to court and says we'll take a summary judgment, it looks to me like that could be the NCAA's Waterloo as an oversight body on major college athletics. What do you see in these cases if the NCAA said we'll take it to trial, we'll let a judge decide this, and the settlement's off, we'll see what's going to happen here? Do you have any thoughts on that?
I would find it unlikely if the parties were able to come to terms in some type of settlement. If the two parties to a lawsuit want to settle a particular case, it's very rare for a judge to not give the parties the time to settle if they both do want to settle. But I'm not sure the NCAA can afford the financial ramifications on the other side. I'm not sure that the model that we know will be at the NCAA and then the conferences. I'm not sure that would exist. There certainly could be a world where the SEC doesn't want to be in the NCAA framework anymore. Same with the Big Ten or vice versa. If you're big enough to exist on your own. So I think that's the compromise everybody took. Let's pay a huge chunk of change to the athlete right now, and let's try to keep some semblance of the model. And if it goes to trial, I think all bets are off.
Yeah, I do too. So here we are. We've arrived at this point. What's next for this situation? What's going to happen with the two sides going forward? I don't mean necessarily predicted, but what are the steps going forward? And can you forecast any kind of timeline, or how long do you think this particular process goes on for?
I mean, we'll know fairly quickly whether the settlement's going to be approved or if it's going to be rolled back. That's weeks, right? And then there's a process of athletes to opt into the particular settlement. So, process of a couple months. But the House settlement's really the first domino here. Can't really predict what the judge is going to do here, but I would imagine this case. I'd be very surprised if the case didn't get settled. It might take a few more weeks, months. They might tell the parties to go back to the negotiating table. But I do think this case ends up getting settled in some way, shape, or form.
So you called the House the first domino. Once that goes, what are we looking at after that?
House, and then the next question is whether any of these schools are going to unionize, when it's going to happen. The question you asked before, if it's going to be at the conference level, the NCAA level, but I think the unionization question is right after that. So House really pertains to limited revenue sharing, and then the next question is these kind of more complex employer-employee questions and collectively bargain for revenue sharing, and that's the next level here.
Now, when you look at all this stuff and you're participating in this stuff and have such in-depth knowledge of it behind the scenes, we were talking earlier, you can study the sport from a historical perspective. It's something I do. It's something I've devoted a lot of time to. You have as well. Many others have as well. But the vast majority of fans of college, this is a college football site, so we'll just talk about college football, which is by far the biggest and most popular, go to the games and enjoy the games. They're home on the weekends on Saturdays, and they watch 10 or 12 college football games on a college football Saturday and pass out on the couch at 2 a.m. None of this stuff matters to them. So when you're considering what's going on behind the scenes and then the product on the field, the thing that everybody has fallen in love with since founded in 1869, it really blew up in the 1890s. Does any of this stuff affect what happens on the field? Has the product on the field never been better? Is there a breaking point where fans will start to care? What are your impressions from being around and hearing from people about that end of things?
I mean, we don't, I think it's somewhat self-evident, right? The transfer portal was kind of caused by lawyers in this kind of range of NIL, and whether for better or for worse, it does change the product on the field. I think we're leaning more heavily towards money being the biggest factor in kids picking schools. So I'm not sure that that's great for the purists of college football, but that's where we're at. And on the flip side, people have gotten used to this model of athletes picking it for the love of the game and playing time and picking a coach. But I don't think it's quite fair in this day and age if athletes are making hundreds of millions of dollars for school that they're not getting paid at all. Do I think, I just think that the combination of NIL and transfer portal window happening at the same time have supercharged change. It's not really a gradual change.
Right.
I think that's the problem. But like I said earlier, we're kind of in it at this point. We just got to make the best of it.
Yeah, the shock of the revolution. The revolution it's been rolling. It's been shaking for more than 3 years now, and we got a ways left to go. So it's played out as stunning as it's been at times. It's actually played out pretty well. We'll find out this year with UCLA, USC, and Washington, Oregon in the Big Ten how unusual that is. And we'll see if some of this stuff starts to impact, but it's, for a revolution, we've managed to keep the sport intact. The 12-team playoff coming up this year should be very interesting to say the least. Yeah. Dan, it's been truly a pleasure to talk to you. I love your stuff on X, listen to your podcast, Conduct Detrimental, time to time. You got your book, so take a minute here. What are you up to? Where can people find you, and where should they engage with you if they're interested in what you do?
Yeah, I am on social media at Sports Law Lust. You can. I'm actually probably pretty big on LinkedIn for those professionals out there. But yes, the book is called College Sports Law in a Nutshell. And yeah, try to eat at least once a week, put out some content on the latest in sports law. So yeah, College Sports Law in a Nutshell, and then my podcast, Conduct Detrimental, the easiest two places to find me.
All right. I love it, Dan. Thanks for coming on and taking the time with us. And I'll see you around the social medias for certain.
Great. Thanks, Mark. My pleasure.
All right, my friend. Take care.